just when you think you cannot have more moronic decisions out of the United States Court of Appeals, let's say by the Ninth Circuit out there in California, then you have the Fourth Circuit out of Richmond, Virginia saying to the Ninth Circuit, hey, Ninth Circuit, hold my beer. Watch what we do. That's right, we have another crazy anti-gun decision by the United States Court of Appeals for the Fourth Circuit out of Richmond, Virginia and Maryland. You're not going to want to miss this one. It's yet another doozy by a terrible anti-gun court. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many best-selling books, including Disarm What the Ukraine War Teaches Americans About the Right to Bear Arms. And don't forget, we got a big announcement coming up with the next book very soon. All right, folks, so today we got a decision from the United States Court of Appeals for the Fourth Circuit. As you know, they're the terrible anti-gun court. Down there based in Richmond, Virginia, also covers Maryland. They're right outside of deep state of Washington, D.C., with the deep state mentalities as a general rule of the jurists on that court. Or you can call them jurists, or perhaps you can just call them politicians wearing black robes. I leave that up to you. And just when you thought that you could have a court that was not, you could not have a court that was as terrible on guns as the Ninth Circuit Court of Appeals out there on the left coast of California and so on, you have the Fourth Circuit competing hard to try to earn the title of terrible anti-gun, anti-American, anti-constitutional court, disrespecting the Bill of Rights in all respects, especially when it comes to the most important right, the right to protect oneself against tyranny in all its forms. Nevertheless, let us carry on. Specifically, in the case of Stephen Robert Brown versus the ATF, dealing with 18 to 20-year-olds, as you may recall, there was a major victory last month involving 18 to 20-year-olds in the state of West Virginia that had sued, claiming that their inability to be able to acquire handguns from a federal firearms licensee was unconstitutional under the Second Amendment, under the Bruin analysis, which of course the Bruin analysis is really the Heller analysis that's kind of gussied up and reaffirmed in the Bruin case. That's Nyserba versus Bruin from 2022. And the judge there, Judge Thomas Klee, the district court judge in West Virginia, found in a compelling decision that indeed that federal law that prevents 18 to 20-year-olds, Americans, by the way, from being able to acquire handguns from FFLs violated the Second Amendment and the Bruin Standard in all respects, and therefore he enjoined, initially at least, he enjoined that law from being enforced against the plaintiffs, and he then, though, at the request of the ATF, says, well, they asked for a stay of the decision in many respects, saying, well, don't let this decision go into effect. We don't want to have to tell our ATF agents the hard work of that they have to respect the Second Amendment. So unfortunately, Judge Klee, in his decision, he said, okay, I'm going to agree that this violates the Second Amendment. I'm going to state that this should be enjoined, but I'm then going to agree with the ATF and I'm going to stay, which means to pause or freeze the effect of my judgment. So Judge Klee enters a victory for the Second Amendment, a judgment in favor of the Second Amendment, but then he basically stays it with respect to everyone except maybe the plaintiffs. There's a little bit of discussion you can have about that. But by and large, he stayed that decision with maybe some minor exceptions here involving the plaintiffs and maybe members of the West Virginia organization that helped bring this lawsuit, specifically the West Virginia Citizens Defense League. But nevertheless, that's not the big point here. The fact is that the judge stayed the decision from going into effect. And then what happened just now, the United States Court of Appeals for the Fourth Circuit has just used a new excuse to make sure that stay remains in effect for years to come, which means that people in West Virginia and throughout the Fourth Circuit, including Maryland, will continue to have their Second Amendment rights violated if they're between the ages of 18 and 20 and want to be able to acquire a handgun from an FFL, because the judges of the Fourth Circuit Court of Appeals just entered this order today that says, quote, for reasons appearing to the court, this case is placed in abeyance pending decisions by this court in Maryland shall issue Inc. versus Westmore, the United States versus Price, and Bianchi versus Brown. So that is the decision. Now, the effect of that one sentence right there, that little statement there, is that the stay of the injunction that we won in favor of the Second Amendment, and by we I mean the Second Amendment community. I had nothing to do with the case, so I don't want any credit be given me in any respect. But the Second Amendment plaintiffs won the case, And then their victory was snatched from them with the stay. And now the Fourth Circuit has said we're going to continue this case in abeyance, which is a polite way of saying we're going to let the lower court's decision to stay that decision carry on so that all the other 18 to 20-year-olds in the state of West Virginia are basically SOL from being able to exercise their Second Amendment rights, from being able to acquire handguns through the FFL. Notwithstanding the fact you had a major decision in favor of the Second Amendment by Judge Klee. In fact, Judge Klee's decision was very powerful. Some of the language from his decision that was very favorable that has now basically been tossed in the trash heap when it comes to most, if not all, of the young adults in the state of West Virginia, said the following. This is what Judge Klee wrote. He wrote, "The core issue the court must answer under Bruin remains whether our nation's history and tradition contains analogous restrictions on the ability of 18 to 20-year-olds to purchase firearms. Defendants have not presented any evidence of age-based restrictions on the purchase or sale of firearms from before or at the founding or during the early republic. Defendants have likewise failed to offer evidence of similar regulation between then and 1791 or in a relevant time frame thereafter. For that reason alone, defendants have failed to meet the burden imposed by Bruin." Powerful language, and it went on for pages and pages of language and analysis like this. And again, the text of the Second Amendment says the right of the people to keep and bear arms shall not be infringed. That is the ultimate historical proof of what the Founding Fathers wanted and what are the rights to be preserved, pre-existing rights to be preserved by the text of the Constitution. And yet you have judges, even when they rule in favor of the Second Amendment, it's like they're scared of their own shadow and they don't want to be perceived as like being anti-law enforcement or anti-government or something like that. Look, if you issue a decision that's favorable to the Second Amendment, Judge Klee, stand by it. Don't hide from it. Be courageous. You wrote a powerful decision that is clearly correct. Don't hide from it. Don't narrow it. Don't say, oh, well, I didn't, this or this. No. If it's hard for the ATF to teach their agents how to comply with the Constitution, that's not your problem. That is the ATF's problem for enacting and enforcing an unconstitutional piece of legislation. So don't do that, judges in America. You stand up for the Constitution. You swear an oath to the Constitution. You need to abide by the Constitution, and you make sure that the people, especially government litigants, such as the ATF that are in front of you, they in particular must comply with the Constitution, because the whole purpose of the Constitution is to restrict government conduct. So those of you out there that think you're part of the deep state and you're buddies with law enforcement and you're buddy with government, no. Your job is to make them toe the line, to cross every T and dot every I, because they are the government with infinite resources and millions of employees on the federal government payroll alone, and they should be forced at every turn to justify in all respects their conduct. Because the power to tax, has the power to tyrannize, the power to destroy. You courts are one of the last lines, if not the last line, but one of the last lines of defense against tyranny. So it's your job, when you see something unconstitutional taking place, you need to stop it. That is the irreparable harm. It's your job as a judge to help stop. Don't get scared. Don't get worried about some newspaper person writing about you, complaining that you upheld your duty, you upheld the Constitution. You swore an oath to the Constitution, you got to follow it, no matter where it leads you to. So anyway, with that said, the bottom line is Judge Klee, powerful decision, but he stayed most of his order, if not all of it. And now the Fourth Circuit has come along and said, yeah, we're just going to hold this case in abeyance, which means we're going to maintain the status quo of young adults in West Virginia are not going to be able to exercise their right to keep and bear arms fully, which is pathetic. The good news is that this is my prediction. You've heard it here first. I stand by it. In the year of our Lord, 2024, 2025, that Supreme Court term coming up, we're going to see the Reese versus ATF case out of the Fifth Circuit, out of Texas and Louisiana. That is going to go to the U.S. Supreme Court, is my best guess. And I think we're going to win that one big time. But again, it's a shame that there are anyone in this country that have their rights violated the way certain gun owners and those would-be gun owners have their rights violated. We would never tolerate this behavior with respect to any other aspects of the Bill of Rights. But we're watching. We're watching the government. We're watching these courts, and we're doing what we can to ensure that they respect the Constitution as it's written and as it was understood by our founding fathers. It is the governing document. And when you swear an oath to go into the military or become a politician or a sitting senator or whatnot, you're swearing an oath to the Constitution and not to a particular administration and not to a particular political party and not to anything along those lines. You're swearing an oath to the Constitution because that is our founding critical document. And if that is disrespected and not honored, then we cease to be the free republic that has withstood the test of time and given us the greatest country that has ever existed. And we do not want to lose that. And if we lose the Constitution, I think we do lose the country in all respects, because that is the critical document that allows us to protect our freedoms against government overreach. And that is very important because, as history teaches, tyranny in the form of governments is a very dangerous and bad thing in all respects. And we don't want to see overreach here by any government, especially our own. We need to work hard to stop that from occurring. The Founding Fathers understood this, and we understand this here at the Four Boxes Diner, and I'm sure you understand that out there as viewers of the Four Boxes Diner. Okay, well, there you have it. Unfortunate news out of the Fourth Circuit Court of Appeals, but they're terrible on guns. They're not a shock. Hopefully the U.S. Supreme Court steps up, grants cert in Bianchi, and that will be a great start for teaching the Fourth Circuit how to comply with the Constitution as it's written. So there you have it. All right, folks, don't forget to follow me on X at Four Boxes Diner. Make sure you hit the subscribe button here. We keep losing subscribers for some reason. So subscribe and resubscribe to be safe that you're not getting knocked off. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.